But I'm going to launch into a few things to start off with that I think, really everybody needs to know, and that is, what are the basic estate planning documents that a Washington resident needs to have? So the first thing that you need to know is there are no two states that treat death the same. That means that it's very hard for you as normal people to figure out what are the rules for me. So let's say I want to Google something or hop on the internet to take a look and look up, geez, was my neighbor really, is that really a good idea? Or my sister tells me I need to do this, and she lives in Alabama. I mean, how the heck can you tell what's true and what's real? So that is of critical importance, that there literally is no two states that treat death the same. We're going to talk about Washington because that's where we are. A couple of questions. Once out of state, I'm going to throw those answers in. So obviously, the device I want to use depends on where I live. If I were to live in California, because I feel like that's one that you all pretty much know, that the taxes there are unbelievable. But if I lived in California and I pass away and I use a will, there is currently a 14% tax on everything I own just for going through probate. Well, I'm not going to go through probate in California. But what does that mean to me here? So those are some of the interactions we're going to talk about. Okay? So, Washington. Fabulous place to die. It is. It pretty much, other than the estate taxes, which, there can be planning, it pretty much doesn't get any better. So I can move from virtually 40 some other states and get darn near a 15% raise just by moving here because we don't have an income tax. You want to know why everybody's retiring here? Well, there's a big reason right there. So, in Washington, we consciously as a state do not make our money off the business of dying, as opposed to my California example where they're charging people 14%. So, in Washington, it is the same fee to settle your estate or go through the probate process for everyone. And that is a $235 fee. It doesn't matter if you're Paul Allen, you're Bill Gates, you're Cynthia Worth. We do not make money off of the business of dying. So we do not need to spend a bunch of money with devices meant to avoid a problem that we don't have. Right? One of our questions that I had, and a very legitimate, is, well, what about this business of, do I use a trust or do I use a will? That's what I hear a lot of the themes of the questions. Generally speaking, as a general rule in Washington, we use a will when we die. That does not mean that there aren't circumstances where we might use a trust, but we are generally speaking a will state. And, right, all of you just learned kind of a bonus. What's California? It's a trust state. They all use trust to avoid that tax that we just talked about, or really administrative fee. So that's one big change. A will. Most of us are familiar with a will. I write a will, which I can change every day of the week if I want to, as long as I have sound mind and while I'm alive. And it's pretty straightforward. All of us need a will, at a minimum. So, that's not, I only need a will if I have young children. No, we all need wills. I don't really think I need a will because I'm married and everything just automatically goes to my spouse. No, not the way it works. I need a will. Everyone should have a will because it saves blood, sweat, and tears. It is one of the biggest gifts you can give, first of all, your spouse. Here's my promise to you that things can go a little bit better and you don't have to deal with anything more than all of these other particular issues. It is a gift. Planning your estate, making sure your affairs in order and having that in order is a gift to the people that you leave behind because things go better. I really have yet to experience a situation where it didn't go better because somebody had documents. And I want to make sure people do not buy into the myth, well, I don't need a will. We all need wills. Put somebody in charge and we tell people where we want our stuff to go. We're only limited by our imagination. We're not going to talk about the contents of a will, but suffice to say, I can leave my stuff to whoever I want. I am married. I don't have to leave my spouse one penny. The concept that I know many of you are aware of, that Washington is a community property state, does not mean that because I'm married, when I die, everything goes to my husband. What community property means is that when I get a paycheck of $1, and again, I'm married, 50 cents of it is my husband's and 50 cents of it is mine. There's a couple of exceptions to that, which are very important, and most of you have this question. When you inherit something or something is gifted to you in Washington, that is your separate property. So, I have one daughter. I die, and I leave $1 million life insurance policy to my daughter. She's married, and is that husband going to take half of that? Okay. That is her separate property, and we kind of joke about only she has the power to screw it up. If she's silly enough to put it in the joint checking account, we can kiss that goodbye. But I want everybody to understand that interaction. What does community property mean? Okay. So, does anybody have any questions about wills? Isn't that great? We kind of all know what a will is. They're pretty darn straightforward. Okay, no questions.
I got one. We moved here to Washington from Colorado. Do I need to change my will just because I moved?
It is a good idea to have a checkup. So that is an important conceptual question. Is I go on vacation to Cambodia, but I live in Washington and I die there. Well, what happens? Guess what? I'm a Washington resident. My Washington will is respected, throughout places. If you passed away, I'm not saying that the world would come to an end because you have a Colorado will. But if we had any issues, we've got to deal with Colorado law. What a pain in the rear. So pulling that together and making sure you have the right documents for Washington, great idea. Okay, in Washington, 5 documents. Now notice that I talked about a will. Quite frankly, I do a lot of my practice where that's not my primary focus. My primary focus is what do I do with you while you're alive and how do I protect you? How do I protect you from losing it, right? Getting sick, being in a coma, all those things. I know I've done a great job and that your will's going to work. What I don't know is what craziness might ensue prior to that. So, back to those documents. Those are key documents we're going to talk about. We're going to spend a lot of time talking about our durable powers of attorney. The first document most of you are familiar with is called a healthcare directive. Some states call it a living will. The general premise is you get to make a statement if you have been taken off life support. This is what you want done. For me, I don't want you to give me any artificial food and water. That's my choice. it's very, I believe, critical to understand that your healthcare directive is not, hey, you decide what's going to happen to me. The healthcare directive is a document where I say, if I've been taken off life support, this is what you do. Big difference. We also have a document that is relatively new on the scene, I feel, like definitely in the last 10 years, but becoming critically important because I look at it as a way to make sure we start things off smooth. It's called the Disposition of Remains. We're a little behind the times, and we're just now getting on target to be cremated. So our default, really on the West Coast, is to bury you. Maybe even people have experienced this. So if I want to be cremated, I need a legally binding contract to make sure that that happens. Or when I pass away, we've got to go around and find everybody in the chain of command to sign off, which is a pain. It's certainly a pain if my family members are on vacation. It's certainly a pain if I don't want to be embalmed. Well, they can't just leave me on the table while they're looking for my daughter. So it's a document that says, this is what you do with me, generally speaking, buried or cremated. Here's who's in charge. I think unless somebody's really been through a death, which lots of you in this room, you can't be selfish and think about you. This isn't about you, you're dead. This is about the person and the individuals that are trying to carry out your wishes. We need the very first thing that happens to go smoothly. We don't need to be fighting over, I know Mom told me 10 years ago you're to be cremated. I know she said she wanted to be buried. I know she doesn't want a viewing. I know she wants to wear this. This is not a great way to start out this estate settlement process. So it's pretty amazing how I can say, pretty straightforward. I want to be cremated as long as you're certain I'm dead, because I'm afraid I'm going to be burned. And I'm putting this person in charge. Pretty straightforward. Any documents that you're doing, and sometimes I get up on the table so that you really hear me, but I got heels on, so I got to be careful. You do documents where you have a first, a second, and a third choice. To me, if you're going to say, if I do documents and my husband's in charge, to me that's a crap job from my attorney. So I'm supposed to remember, if I lose my husband, that I no longer have any documents and no one's in charge, and I'm right back to square one. I'm supposed to remember that after I just buried my husband? How crazy is that? Do not let your attorney, and do not think that you don't need multiple choices. I mean, what if I put my sister in charge and, she's in Venice? Or what if I put my sister in charge and she dies? Or any number of things. It's not enough to have a plan A. I want a plan A, B, C, at a minimum, preferably D and E. Okay, now that we got you buried or cremated and it's going well,
Can the disposition of remains, can that be part of your will?
Well, interesting legal question. So, the disposition of remains has come out of, as you can imagine, a lot of nasty, ugly problems. But the problem that we're trying to deal with can't be undone. And that is, oh yeah, I read, Mom passed away a week ago. I'm not a bad person that was looking through every cupboard to figure out where her will was and read it while the body's still warm. So we read the will and shoot. Whatever you do, don't cremate me. So the reason we're doing disposition of remains is not just to make it easier on the legal chain, but it's because in the olden days, we put things like that in the wills, and they served to be the biggest guilt factors ever known to man. I mean, how am I going to feel if I read my mom's will and it says, bury me, and I just got done cremating her? So there's some practical realities that these things have come from. I mean, we don't think, hey, let's go read the will to figure out what to do with the body. Yeah. Okay. So far we learned about the healthcare directive and the disposition of remains. Now we're going to talk about durable powers of attorney. Quite frankly, there's not a more important document to have. Why? It's only effective while you're alive. And it gives the two. One's for health, one's for money. These documents give someone the legal authority to make decisions for you if you cannot make decisions for yourself. So you see how I look at it is, I'm your attorney in sickness and in health. Once you're dead, I don't have the same concerns that someone might exploit you, or, Jesus, somebody taking advantage of you, or I've known you for 20 years and now you walk in the office and tell me you're going to marry a 21-year-old and give her all your money. I mean, those are alarming things to me. So I'm much more worried about when you're alive. And I think about a lot of these things from the perspective of me. And I actually had a situation where I was in the hospital for 6 weeks, and I'm admitting it, I did not have durable powers of attorney. I was so young and stupid. But we should all have them. You might have very different people that you're going to put in charge when you're dead to run your estate versus who you're going to put in charge while you're alive. When I didn't have my durable powers of attorney, I learned a couple of really important things. My husband said, "Hun, under no circumstances could I ever take you off life support. You've got to take me off." Oh my gosh, how great. Let's hope we don't have to have lots of those test runs. But then I got to a better decision because, somebody was able to tell me, hey, I can't do this. I put my mom in charge of my estate because if I'm dead, I don't ever have to hear about what she thinks in my checkbook is inappropriate and where I'm spending money. But on my durable, I don't want to wake up and have to rationalize my life to her. So I think it's really great that if somebody makes you think about it, that you might have different people with different skill sets to do these jobs. Maybe one person is burying you. Maybe they're really bad with money and you need to make sure they're honored and decision-free. You're like, okay, you can bury me. Okay? Maybe someone's a nurse but maybe not good with money. Maybe they're your healthcare person. But you should expect to put a lot of effort into thinking those things through. And again, we're so apt to put the time and effort into our will when I want you to put a lot of time into your durable powers of attorney and who those individuals are. I also want you to know that there's a belief by people when we use the words durable power of attorney that means one thing. And I think a lot of people believe that everybody has the same one. We just all need one. No. You have to make choices. You have many, 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 many powers. You have to say, I'm going to put you in charge, and these are the powers you have. So it's normal for you to expect when you're meeting with your legal counsel to get your documents drafted that you're talking about what power to give. So, a good one for me, the law doesn't allow anyone under any circumstances to change your will. Kind of sounds like a good policy. Well, but what if somebody can change my beneficiary designations? Well, quite frankly, I'm young and poor. All I have is life insurance and an IRA, 401k. Well, those pass by beneficiary designation and by contract, right? So if I allow somebody the power to change that, isn't it the same thing as changing my will? Do I really want to do that? It is not unreasonable for you to have expectations in meeting with your advisor to know the answers to those questions. I joke with my clients and I ask questions about, well, when you were with your previous attorney, and you met, was it horrible? Well, no, it was pretty good. Well, they weren't doing it right. And I think those of you that have had interaction with me know that it's not just my job to educate you so you can make those choices. It's also to point out, perhaps, if you tell me a 20-minute story about your child stealing money from you and you try to put them in charge of your finances because you don't want to think about it, you're going to get pushback from me. So, just like if you say, well, geez, my daughter's the oldest in the family. She's going to be in charge. And maybe she's not the right fit. You want the right fit. Haven't every one of us in this room, couldn't we tell a story about someone that we have interacted with that we feel wasn't treated appropriately while they were alive, or somebody stole money for them, or somebody married them, or somebody did, something in that time period where maybe they weren't what they were 20 years ago? Well, that durable power of attorney is the critical document. So, again, I just see a big difference between the will and the durable powers of attorney. I'm going to just speak real quickly to a problem that we have as a nation and that we're trying to deal with. You guys all remember this new law a few years ago called HIPAA. Okay, none of us know what it means, but it seems like we've got to sign like 8 more things every time we go to the doctor's office. So it's all about when they release information about us, and we should all be sensitive. I don't want them telling, what my, level of X, Y, or Z is. We've got to have privacy. Okay, so you guys all remember probably dealing with your parents where you have a durable power of attorney and it says, this kicks in and I'm in charge of my mom when 2 physicians declare her unable to manage her affairs. Right? We've all read these, right? Okay. Well, now it is illegal for a physician to release the information about whether or not we have mental capacity, right? Because we have HIPAA. So one of the things we're all doing is making sure that our durable powers of attorney are updated to be HIPAA compliant. And quite frankly, all of you are super young, so that's not the issue. It's making sure your parents or the individuals you're going to be in charge of, that those are updated. Which I do want to speak to that. When I put you in charge of my financial power of attorney, I won't kill it. You have an obligation to some degree, which the law is working out the outer limits of that, but you have an obligation to keep an eye on me. You can't say, well, that Cynthia, have you seen how much money she sent to Publishers Clearinghouse? And, we don't get to sit back and not protect people. And that's a lot of what the law changes in this area are about, is the new era of, no nice way to say it, thievery, abuse, bad people, kidnappings. A couple of years ago, did I think, being a tax attorney, that I was going to have to deal with kidnappings? We don't even have adequate laws in this country yet for stealing a parent and taking them across state lines because they're not being fed properly. I mean, when I had a question from someone about when should I update my documents? Unfortunately, this is now an evolving time. And as a general rule, looking at all of you as either having a tax problem or borderline tax problem and the lay of the land, the 5-year mark, we should be updating our documents every 5 years. I'm sorry, but we're here. Now, let's say I put Ken in charge under my power of attorney. My husband, let's say, Now Ken has my power of attorney, and it's 20 years old. And he walks into the bank, and he says, I'm going to transfer $20,000. Give me $20,000. Okay, so the bank teller takes a look at it. They go in the back room, talk to somebody with more authority. And they're like, you know, that Ken, he's suspect looking. We're not going to give him the money. Or the durable's 10 years old. I want all of you to know you have no rights to do a durable power of attorney. It's a privilege under the law, not a right. There's nothing we can do to force somebody to honor a power of attorney. The only thing we can do is make sure they're relevant and up to date. Now, wouldn't it matter to you if you were in charge of a bank and I came in with a durable power of attorney that was a year old, you'd feel a little bit better about it than if I came in with one that was 20 years old. Doesn't that make sense? And again, we do durable powers of attorney, so in a crisis, life goes better. Okay. Everybody with me so far? Uh-huh.
What legal protection is there then, if that power of attorney can be challenged?
Excellent question. Okay. So the way that the law actually works is if Cynthia goes crazy, we have to appoint a legal guardian for her. That's the law. Okay, a legal guardianship, quite frankly, we'd probably all rather have about 5 colonoscopies than go through that. It's horribly expensive. It's beyond offensive. I can lose, maybe I lost some marbles, but I can lose my right to have a gun. I can lose my right to vote. The court sends somebody out to examine and to figure out, really, am I crazy or what's the deal? It's expensive. It's just plain not what we want to do. But it is the law. That's the way the law works. We have the ability to try to circumvent that process and do a durable power of attorney. So I want you to see the difference. That's a privilege that we try to do a durable power of attorney so we don't have to go down the guardianship road. But if Smith Barney says you're not getting at that $1 million IRA because I don't want your durable, you have no recourse. And guess what? That's not just Washington. That's the whole lay of the land. That's the nature of a durable power of attorney.
So if my mental capabilities have declined within that relatively short period, that they set that durable power of attorney document up, it's gone with the wind?
You know, I got to tell you, that's where good advocacy can come into place. I find that there's a lot of financial institutions that say, oh, Cynthia, we understand that Joe has went crazy, and we're going to put his wife in charge. We have no problem. We just need him to sign this document. And I'm like, I cannot participate in having somebody that we all know can't sign documents. Do you realize the dilemma there? But here's the flip side of it. They have absolute liability. So for them, a financial institution, if they have a court order that says somebody's the legal guardian, that's very different than a durable power of attorney. The more craziness and risk that abounds for financial institutions, the more anal retentive they're going to get. The moral of the story for us is, do what you can. Have fresh durables. A 10-year-old durable, a 20-year-old durable. Somebody actually brought up, you know, should I update my will? It was done in the 60s. Yes. Now, I in a lot of ways, those are the good old days. Let's face it. I mean, things are faster. They're moving quicker. We're having new problems that tomorrow we won't even know about the problem that's going to be the new problem then. I mean, things are moving faster, and we have to update. So, that's one of the best things that I think you can do to protect yourself. So, and it matters if I go into Security State Bank and I say, hey, Mike, I happen to be in here. I'm gonna give you a copy of my durable. Don't you think it matters to Security State Bank that when I was fully capable and on top of it, I brought it in and said, here's my durable? There are things that we can do that can help that process. Anybody have any durable power of attorney questions? Would they feed you? You guys are just like so quiet.
So if informing those durable power of attorneys, doesn't matter where we go. I mean, it does. The answer is yes, it does. But I mean, where do we go to get those? I mean,
Durable power of attorney?
yeah.
Yeah, whoever's preparing your estate planning documents, it should be all together. So like if you came into me to do estate planning, you're not leaving without your durables. And again, making sure that you're cared for during your lifetime and that I have adequate things in place is in a lot of ways more important to me than if you died.
All attorneys are not equal. Some are well versed in this legal the wills and stuff. Some of them do car crashes, and
Yeah.
get the right attorney.
Well, I would tell you that a phenomenon that is happening, and you know what, you see it in your doctors, you see it in your mechanic, I need you to understand it in the law. Things are getting specialized. You know what, 40 years ago, if I was practicing in Olympia, I'd probably do divorce, I'd probably do estates, I'd probably do some personal injury, I'd probably have some criminal cases. Those days are long gone. We have a very complex set of laws that I will tell you in the last 10 years, we made more laws than we did in the previous 60. And we don't have any attorneys left. We have a massive attorney shortage in the United States of America, which I was just talking to somebody about. What? There's no attorney shortage. And, Cynthia has a big mouth, so she's just going to tell you. I mean, yes, we're graduating them, but they're not practicing law. They're not going out and practicing law. So, massive shortage, and then to add to that, we just had a doozy of a tax law come through, and anybody that was on the fence, whether they were a CPA or an attorney about retirement, well, that just kicked them over the edge. I don't want to learn it. I'm retiring. And I mean, it's the doozy. This is the largest massive overhaul we've had since the 1986 tax code. So, plenty of people, I don't want to learn it. So, you couldn't be more right that not all attorneys are created equal. I think you should look for and really insist in your advisor that you choose that. I just don't understand how you can draft documents or do a state settlement. You gotta do both, right? I'm a better drafter because I know how to go through the process. I learn something new every single solitary day without exception. And so, how can I do one without the other? I have a hard time understanding that. How can I be really good if I've never probated a will? Or if I've never transferred a piece of land to somebody? So, I think that's really important. I also think it's a dead giveaway if you don't say, oh, I got my confirmation of my appointment in the mail today, and there's this big thing I gotta fill out. If it's not horrible, everything you have to do to prepare to get your estate plan, it's not the right plan. In our office, there's a few of you out there that can attest to this. In our office, you have to bring legal proof of every single thing you own in order for us to do your documents. Why? There's over 20 different ways to leave an asset when you die. Anybody ever signed a beneficiary designation on their life insurance and said, this is where it goes when I die? Well, that's one way, that's by contract. Anybody ever sign a 401k or IRA beneficiary designation? This is where it goes when I die? That's another way. Anybody ever heard of JTWROS, joint tenancy with right of survivorship? If I die, that's automatically passes. That's not your will. What kind of schmuck am I to charge you money and say, everything's going to be fine when your husband passes away or your wife passes away. Here's your will if nothing passes according to it. Right? So, no pain, no gain. And I think some people would say, the downside of me being a farmer, I know tractors don't have a title. I know logging trucks do have a title that are sitting in your field. When I mean legal proof of everything, I mean legal proof of everything. How am I going to say to you, hey, do you realize that we're giving the farm to Joe? Doesn't he need some equipment? So we're going to leave everything else to the kids, and so he's got the log splitter and the city slicker's got this. I mean, that doesn't make sense. What about the equipment? Quite frankly, it took most of us a lifetime to even buy the log splitter. Right? If only I'd bought the log splitter earlier. Right? I mean, is there some unwritten rule that we don't buy the log splitter until we're like super old? I just got a log splitter a couple of years ago. Okay? I just want to say to my grandpa, yeah, you lied to me. There is a log splitter.
The law says you can't own one until your shoulder goes out.
Oh, yeah, there you go.
That's why when everybody buys one.
Pretty much. Yeah, in our family, if you can't maintain at least 10 cords of wood, that's a serious flaw in your character. So anyway, okay, everybody feel like they know the basic documents for a Washington person.
Except 5.
So I've got my will, I've got my financial durable power of attorney, my healthcare durable power of attorney, my disposition of remains, and my healthcare directive. I have a question for the group. If I'm on my deathbed and I go over here to my good friend and I'm like, listen, I want you to give my car to my girlfriend Susie. I want you to give all my jewelry to Joey. This is what I want you to do. Is that in any way legally binding? Could you even do that? No. And we don't want to live in a world where those kinds of things are what our family has to live with after we're gone. That's not clear direction. That is only setting people up to fail. I want all of you, hopefully, to make your decisions and put them in writing. It's also surprising to me how many people say, well, you know, this is what my mom told me I need to do, and so this is what I'm going to do. Well, guess what? Mom told everybody something to do. That's why the law doesn't tolerate that. It is what's in writing and what's in a legally binding way. Does the sticky method work? Well, I went around and put stickies underneath everything in the house. I know a lot of people do it, but that's not the way. So, you know, those are some of the practical sides of things. Okay. I know you're all dying to know about taxes. Did you have a hand up? Okay. Right? You're all dying to know about taxes. Okay, well, first of all, we have the most exciting tax change that most of us have ever been a part of. I guess I want to be your newscaster. I think there's something that everybody should know. One of the greatest things that we have done in this tax code, but yet, I got to tell you, in over a year, I haven't heard one person talk about it. For the first time, this country has said, or certain people have said, you know what? Are we really doing a good job with with our elders or with people who are aging. We told them to save their whole life, and then we tax the crap out of them. So, for the first time ever, here's one of the new tax provisions you don't know about. If you make $80,000 or less, you don't pay capital gains anymore. And that is specifically targeted at our aging population. Anybody hear that on the news? Anybody talk? Isn't that a great thing? I think that's really a great thing. And I want you to see the power of tax law and how it's really just social engineering. And isn't that one of the exciting changes? As I talk about maybe some of the less exciting changes. Yeah.
Get a clarification on that. We're all foresight owners, so if we do a logging, it's not at all out of range for us to do a 10-acre logging and earn $250,000 to $300,000 on it. Capital gain.
Yep.
But being retired, our actual earnings are quite low.
Mm-hmm.
So we can pretty easily get under that 80,000. Are you saying that there's no capital gains now on that timber harvest?
Yeah, well, we have now relief for a certain segment of the population to not pay capital gains tax.
If you don't have earnings of greater than
Right.
Is it 5A?
Okay, now listen. Okay, this is one of those, that's the general rule. It's the tax code. We all know that means there's 821 billion exceptions. But how great is it? I want all of you that you think might apply to consult with your tax advisor. This is a really big thing. But you're not hearing about it. You know, I just think it's pretty great. Okay.
Can I get another clarification? What about a timber sale? Is that the same thing?
That's not earned income in the same way. So,
And what about the computerized tax preparation forms that most people use? I can't remember some of them.
TurboTax?
TurboTax, are they going to up on that?
Yes, but come on, people. You know, if you use TurboTax, that it's, not written by the government, but it's on the conservative side. Not that there's anything wrong with being on the conservative side. Some people say my philosophy is I want to sleep at night. Other people want to ride that line. Okay, but TurboTax, conservative, right? We all know that. So, sorry.
Does this go away in 5 years?
Oh, let me get my crystal ball. Yeah,
I understand that.
Right.
Unless you're really wealthy, whatever's in a business or something, you don't have a tax break, but only for
Yeah,
5 or 6
and probably you're seeing a little bit of my bias. I am just, first of all, I've read every word of the new tax code. And I just cannot believe the misinformation being given to the public. And how the heck are you supposed to function? I mean, do we really need to live in a country that we all have to have our own private tax advisors to be able to figure out what the heck to do? I mean, that's just not a good plan. Quite frankly, the jury's still out. There are certain things we can learn from history. We don't take tax breaks away from people in the middle of the year. When we do it, we usually do it on January 1 or December 31st. I don't have a fear that I'm going to count on this and magically they're going to rip the rug out from underneath me. But yes, the majority of the current new rules are gone in 2025, making it very difficult. And, I have this nasty little thing that I say around the office anymore. If I hear one more person say I don't have to plan because the number went up, I'm just going to slap them. Okay, if you die in this window, well, guess what? If you can predict that you're going to die in that window, then you're in the wrong profession because we need to get you a different job. We got to take it one day at a time. Isn't that the frustration that we all have? So, when it comes, I'm sorry.
Does this tax year 2018, does this apply to 2018?
Yes. Yeah, these were all the tax laws that went into effect last year. So let's talk about how it relates to death. And because I know you're all really wanting to know about death taxes, I want to talk a little bit about income taxes, and this is really technical. So, are you ready? Most of you might not have been through a death and don't know that one of the best parts about dying is that your assets get an income tax basis step up to whatever the fair market value is as of the date of your death. So if I bought a piece of land 30 years ago for $10,000, I die, we get it appraised, and it's worth $20,000, and I leave it to you, your new tax basis is $20,000. You turn around and say, thanks, Cynthia, I don't need any more land. You sell it the next day for $20,000. There's no income tax on that appreciation. That's the way it's always been. We do not, if you die with appreciated assets, other than retirement plans and IRAs, that escapes taxation. Right? Okay, yeah, you got to die to get it. Okay, but let me go one step further. If I'm married and I live in a community property state, which there are 8 of us, and my husband dies, I get a basis step up on all of our stuff because I live in a community property state. Why is no one jumping up and down?
I don't want my wife to know that.
So it literally means I can sit there with my husband and say, you ain't looking good. I'm not going to do that timber harvest quite yet. My husband died. I would get an appraisal on our timber and our land as of the date he died. And then I would harvest it and likely pay no income tax. Now, why am I telling you this? I'm telling you this because it's the greatest thing since sliced bread. And I'm telling you this because everybody says to me, when my spouse died, I didn't do anything. I didn't do anything. I had all these documents. Look at me, I didn't do anything. And I just want to say, so you just gave the government free money because you didn't want to spend $500 or $1,000 on a timber cruise. Or because somebody told you, you need to appraise, but hey, I don't want to do that. You're leaving money on the table. Now that the feds have raised their limit on how much money you can pass estate tax free, well, come on, we're Americans. We're not satisfied with just that. What else can we get? Well, we're forgetting about our income tax. We're forgetting the workload that needs to be done when the first spouse dies. We're even forgetting the workload when anyone dies. We need our income tax basis step up at death. It's free money.
Question. Some of us have a few farms in different types of entities.
Yep.
LLC is one. And so how does the basis work for an LLC when a member of the LLC dies? Might have in his will, it goes through, my such and such.
Mm-hmm.
What happens there? How do you keep track of what happens?
Excellent question.
Okay, I need to know.
So every single thing, and I'm getting pretty close, I think, after the last few weeks, every single thing can be valued. I can value half a book that somebody wrote that's a famous author that died. I can value a 21% interest in an LLC. I can value my beautiful hair because I'm Gwyneth Paltrow and they're going to sell it. I mean, it is crazy, but there is literally a valuation expert that can value anything. We all know it's opinion-based. I'm not saying I'm on board with how they do it, but everything has a value. We don't like S corps or C corps, and we generally never own land in them because we don't get a basis step-up, among other problems. One of the reasons why you've all chosen when you created an LLC, whether you made the choice or not, is because you get a basis step-up on an LLC interest as opposed to any kind of corporate. But everything has a value. It's our job as either the owner of the property, the person in charge, or the legal counsel to work hard to strive to achieve that, what's that right number and that tax basis. It's shocking to me. We all have the mindset, oh, I've gotta talk my appraiser into it's just worth $50. And then I'm like, well, would you sell me that land for $50? Well, hell no. The days are gone of low numbers. That's not the direction. And there's money to be had. Can you imagine what my retirement looks like if my husband died and I just got our timber farm with a basis step up of $1 million? Well, that means a big chunk of my retirement is now tax-free, right? If I was planning on maybe harvesting, I have $1 million worth of basis of money that I'm going to get back before I ever start paying tax. You bet your rear end that changes my retirement. So again, it's something I don't want you to forget about. And it's so important. That's why I told you that before I told you what the tax limits are. Any questions?
Yeah, so in this LLC, say you've got 4 members, okay, and one of them dies.
Yep.
Does the basis get stepped up for the other 3? How does...
Well, no, or we'd be out searching nursing homes for people with one with a banana peel. Okay, only one of you died.
Okay.
But guess what? Do you live in a community property state and you got a spouse? Because maybe you're going to double dip. Okay, what are the current, oh yeah.
How much time do you have after a death to do a basis, like step up basis appraisal?
Another great question, okay? So in a perfect world, we're filing our tax return the first day it's due, which is 9 months after the date of death. I gotta tell you, we just had someone in our office that when they had I don't know if it was Tom Bradley or one of the CPAs down here, they had a huge timber sale, and so their tax bill was $2.7 million. So guess what? That's when they decided, oh my God, I can't pay that kind of tax. What's wrong here? What do I need to do? Like, well, we can go back to 1980 and 1976 and get appraisals and at least get what's, something. I mean, we want timely, there's rules, there's deadlines, but that doesn't mean that all is lost because I know our office has participated in some pretty sweet resurrections of basis. That's really what we call it. In fact, my very favorite, it's hard to find people who have the skill set and actually are qualified to give us an appraisal that's longer than a year old. You may not know that, but in appraisal world, those are special people. And you guys actually have what I believe to be one of the best individuals who is a retroactive, qualified, competent appraiser, and that's Nadine Tauscher. So, those people don't grow on trees. Quite frankly, I do not have one single solitary person in all of King County. Nadine's that person. I tell her, you keep getting old, man. You're going to be like out there as the icon of. She doesn't think that's very funny. So anyway, what is the current lay of the land with estate taxes? Now, all of you are used to this world. I came into practice in 1996, and what was really weird about the world is literally there was only one tax overhaul, and that was in 1986. So it's not really common in people's careers to have multiple major tax, overhauls. Well, but I'm like a brand new attorney. I don't really know that. I've been through every year in practice, the law has changed. So that's been my whole life. And you're all used to dealing with the fact that, quite frankly, 95% of all the last years, we've changed the law in terms of how much money you can pass. That is one of my most important messages to you. No one can do that for you. You should know that number. At least I can count on you versus does my advisor know it? Are all these people going to just call me and say, oh, guess what? Today changed. I think that's one of the things I want you to own. What can I pass free? Okay, so, and also an important context is the federal government has raised the limit on how much money you can pass estate tax free. Is this a surprise? No, it's not a surprise. Even prior to this administration, there was a lot of talk about, should the feds be doing this? We haven't ever made 1 penny off estate and gift since it's been in existence. But do we need all these employees? Do we need all of this? The decision has been made that the IRS is going to shrink massively. And you know what? If we're not making any money off of it, why don't we just push that back to the states? So as the feds have come up and said, you know what, this is kind of one of those things that we're not going to really care about, maybe, I don't know, today, well then the states are coming up. They're just getting their own taxes. Way back in the early 2000s, virtually no state even had a staff in any way. Well, now they got staff. I mean, the states are in it. States are taxing. So, while we have a federal limit of 11, it was indexed for inflation, so it went up to 11.4 this year. The state of Washington allows you to pass $2,193,000. So if you have it in your head that you don't need to plan because you're never going to hit those limits of $11 million, quite frankly, no, you're not going to be disappointed. You're dead. Everyone else is going to be very disappointed. Well, I do say to people, we're spending a lot of time, generally speaking, planning to save on a tax you're never going to pay. It's important to figure that out. I mean, some people say, well, yeah, now that you mention it, I don't want to do anything for those no good kids of mine. Or other people are like, well, yeah, I earned it. The last thing I want to do is, feel like I'm giving 3 rental houses to the government in tax monies. Okay. Those are pretty straightforward limits. We're always going to have 2. If you live in another state or you have property in another state, it gets worse and worse and worse. Big surprise. How's everybody doing? Okay, I'm already over my hour. Do I have just a little bit longer? Okay. So one of the big things that I see that kind of gets a trap for the unwary as you guys are trying to, as a general rule, just figure this out, is I cruise along and I say, well, let me get this straight. Cynthia just told me that every person can pass, let's round the number at this point in the day, I got limited math skills. Every person can pass $2 million in Washington. We're married, and we can all do the math. 2 and 2 equals 4. Well, that's not playing. That's what a lot of people feel. That's not the way it works. If I die, and I have a will that leaves everything to him, you need to know there is no tax when I pass to my spouse. As a country, we don't do that. The United States of America does not tax the first spouse to die because we don't want them on the dole. Well, I mean, it's true. So I take my $2 million and I pass it to you, and you die. How much money are you worth?
4.
How much can you pass for free?
2.
You're going to pay at least $200,000 of tax. That's a pretty big screw up.
Yeah, that's a lot.
But it's what we all think. So instead, oh my gosh.
Red, well, not red.
Well, you guys got to tell me. What are we thinking? Can you see it? Okay. So, Okay, so what do we do instead? It's our first line of defense is the very first thing that we need to do for estate planning is we need to make sure we each get what's coming to us and take advantage of our free $2 million. The great news is there's... Okay. That was a really short marriage, dude. You don't even know me yet. Okay, so the really great news is there's only two ways that we can fix our problem or pay that big tax. Okay, the first way is, this is our daughter. Okay, we could, when I die, because I'm the one dying here, instead of passing, I got my free $2 million, instead of passing it to you, I could give it to somebody else. I could give it to our daughter, and then guess what? I'm passing my free $2 million to someone. Well, I kind of say, if you did that, you'd be lucky you were dead. You can't give money to our daughter when I could live to be 125 in a nursing home for 38 years, which is every rational woman's fear. So, you're not going to leave it to our daughter, who's wonderful, but what are you thinking? He's liking our marriage already. So then, okay, what's the second choice? The second choice is I can die and instead leave my $2 million into a trust. I can even put you in charge, but then when you die, whatever's left is going to our daughter, not your new wife. Right? I mean, I don't want that. So, yeah, look at his wheels turning. Okay, we're not married yet. So, but, yeah, there you go. But I really like the fact that when I examine my true feelings about my estate, it's actually important to me. I don't care if I have 25 cents, because I get to decide this. I don't want the new wife to have it. I want my daughter to have it. And if I have one more story or involved in, the stepmother, right, blah, 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 blah. Okay, so I want to do that in our marriage. Well, isn't it pretty great that it also solves my tax problem? A lot of you, I want you talking about this with your advisor. I don't want you leaving your basis step-up money on the table. I want you doing the work, and I want you to have a great plan, which requires what? No pain, no gain. Right? When you're doing your plan. Oh man, look at that. Okay, I feel like I gotta be drawing something. Yeah?
I know you said this to me in the past, but I can't remember. You wouldn't want your spouse to be the trustee of your trust, or would you?
Well, not all spouses are created equal. And there's thoughts to that.
You could sell your assets.
Right. Everyone can always be a cheat, liar, and break the law. Do I draft every plan thinking that everybody's a cheat, liar, and going to break the law? Not necessarily. There are circumstances, someone comes to me and says, my wife has had a horrible gambling problem, and they've been to Gambling Anonymous 3 times. And then they're like, yeah, I want to put my wife in charge of a $2 million trust. I mean, like, what are you thinking? So it's a case-by-case basis. Everybody should be thinking about those things. There are circumstances in every family that need to be addressed. I have yet to meet the same family twice. And again, I believe it's your advisor's job to educate you so then you have the information to make the right choice for your family. It's not our job to decide. There are some areas of the law where you're like, no, you can't do that. You can no longer provide for a wedding gift in a will. It has to be a wedding gift or a union blessing. Okay, well, guess what? Your attorney needs to tell you that. You can't say, this is what I'm not going to do. But those things are relatively rare that you can't do. I had a gal ask me, hey, I'm thinking about potentially leaving some money in trust for my grandkids. Can I do that? It's your money. You can do whatever the heck you want. I don't have to leave $1 to my husband. I don't have to leave $1 to my daughter. I can leave an education fund. I can leave it to the Salvation Army. It's my life. It's my death. It's my money. I get to do what I want. Again, that's your job. But who among us doesn't need a little bit of help? You know, even I use an attorney to do my estate plan. And for those of you that have been to more than one speech that I've given, I'm part of a family that had a large land holding that's been through the LLC, that's been through the governance, that's been through the death of my grandfather, been through the death of my grandmother. I know how it works. And you'd think I would actually be pretty good at it. I suck at it because everybody is emotional and irrational about their own family. We all have rose-colored glasses, myself included. None of us know what we're supposed to do with our dead mother's body because our mother's not going to die. Your mother's going to die, but not mine. I mean, there's some truths. And I did recently go through a pretty horrific death in our family where I got to see everyone in their shining glory. Because, right, our best moment is when we lose somebody close to us. I kind of take the position that maybe we're entitled to go off the deep end. So, all right, so I'm only 19 minutes over. Well, yeah, I know, after she got it all for me, I'm going to blame that on my husband. So, I keep track. But, does anybody have anything? You know, I mean, I only have one really big issue that I kind of wasn't able to work in the hour that one of you asked me. But it's also the question of, well, what about LLCs? And we could talk for 3 days about that. And I want you, do you feel like you learned something?
Yeah.
Good. We had fun on a Tuesday night? Okay.
When does something go to probate, or why does it go to probate?
Okay, excellent question. What probate is society's orderly way of making sure a dead person's name is not on assets. It is 3 steps, and it is the only legal process that the person in charge gets a court order that says you're done and nobody can sue you. 3 steps. What did she own? What are her bills? Pay them. Who are we supposed to give this stuff to? I'm the person in charge. I did 1, 2, 3. I want to spend my money, maybe if I'm the oldest child or whatever, I'm the oldest child. I want to spend my money. Why should I sit for 20 years and wait for my sisters to sue me? Because Mama loved me best or whatever. Probate is a process that, quite frankly, it's not about any of you. You're dead. It's about the person you asked to be in charge of your multi-million-dollar estate that has to wait 20 years to be sued. That's crap. Especially when we live in an amazing state that's $235. It doesn't matter if you're Paul Allen. That's the fee. But it matters if I'm in charge of your estate, especially maybe if I don't know you that well. Geez, I mean, I don't know what you do. I mean, I want closure. So that's what probate is. It's about that closure.
The fee you're talking about, that's what it costs to record it in the courthouse?
Yeah, that's the fee that your county that you file in, charges for the process.
Oh, probate.
Mm-hmm.
So everybody who dies will go through probate.
Some people decide to use what's known as a revocable living trust to avoid probate. Now, not a big fan. I need a real reason why I'm not going to go through probate. And guess what? Let me just ask you, young lady, if I was going to put you in charge of my revocable living trust, and, I mean, how do you feel about the fact that all my kids could come sue you for 20, 30 years. I mean, it never ends. You have no closure. That's what happens if we think about ourselves when we're drafting, instead of this wonderful woman who's agreed to serve and to be in charge of my estate and take all the responsibility and take the liability. It can't just keep giving and giving and giving for another 20 years where she's wondering. Because death is also about that legal closure and winding up your affairs.
Who can start probate?
So, the person that you name in your will, and most of you, we always call them executor or executrix. The newfangled term is personal representative. I nominate in my will who that's going to be. I get to appoint that person. If I do not have a will, well, guess what? The government has a will for me. Do you think I like it? No, I'm not really liking much that the government does for me. And if I don't name anybody because I didn't do a will, there is a statutory order that things happen, but there is a mandatory 40-day waiting period. How do you think that works with my mortgage payment when my husband died? Well, it's just one of those practical things that, it's bad enough to lose somebody, but then to have the parade of horribles because somebody didn't plan, that's a pretty devastating thing.
You didn't talk about trusts at all.
Okay, I didn't talk about trusts at all. So I want to reiterate, number one, Washington isn't a trust state where we use it as a device to avoid probate. But really, what is a trust? A trust has to have three things. It has to have the person who created it and someone in charge. It has to have property or money or something, and then it has to have beneficiaries. Trusts are probably most commonly thought of is, I have an 18-year-old daughter, and oh my God, I don't want her to get a hold of 50 cents until she's 87. I don't want to ruin her with money. So what I'm going to do is I can draft a trust. I can even draft a trust in my will that says it doesn't even muck up my life or come into existence until I die. Then I'm going to put you in charge, and you're supposed to give my daughter no money under any circumstances until she's 40.
No problem.
Okay? Or I might say, I want you to get her through college. Or I might say, she's got some unique needs, and I kind of need you to keep an eye on her, and I need you to make sure medical insurance is paid. Or any number of things. We're only limited by our imagination.
Well, how can you do that age 40? I was told that a trust in Washington can only be in effect for 21 years.
Not true.
Not true?
Nope. So we have
How long?
what's known as the rule against perpetuity, which is really just made up to torture law students. And it is that if I'm pregnant, my trust that I write has to die within 150 years of this child being born. Oh my God. Right? That is the rule. Because we can't have things go on and on and on and on. And you guys laugh, but you'd be surprised how often, we're dealing with trusts still from the turn of the century. And we're dealing with trusts that are right up against that 150 years because all it takes is a few bad car accidents.
And you could probably just restart it as something else, or if the
Right?
beneficiaries
Right.
agree to it.
Yeah. But my point is, you get to decide. You know what? It's technically a trust if we said, all right, everybody in the room, let's give you $5, and then we need you to go get a wedding gift for Cynthia and her new husband. The fact that we gave him the money with the purpose and told him to go get the wedding gift, that's legally a trust. We don't really think about it until there's a famous case where he decides that he's going to keep that. because he needed the china. My point is, you get to decide. You know, I could say, I want to put money in trust, and I only want it to people going to Gonzaga. Or I only want it to people who are going to be master gardeners, or dahlia growers, or, I mean, and you know what, it can last 150 years after the death of my baby. So, okay. Fun time, everybody. I'm really excited that no one fell asleep.